Get started. I'm Sean Hauser, and I'm joined here by my colleagues Michelle Bodian and Katie Whiteman. We are most of the Vicente Sederberg Hemp and Cannabinoids department. And today we're going to talk about the federal and state regulatory landscape for minor cannabinoids and other trending topics in hemp. And as many folks on the call know, really much of the legislative and regulatory trends right now are focused on, the appropriate regulatory structures for hemp-derived products, food, dietary supplements, cosmetics, in the FDA's absence of, adopting regulations for enforcing existing regulations for hemp-derived cannabinoids. And because of the, FDA's delay in developing a regulatory framework for hemp-derived cannabinoids, including what levels of THC are appropriate for ingredients in food and dietary supplements, states have had to step into the roles as sort of, mini FDAs, and in some states, regulating hemp products in conjunction with cannabis products, and others just hemp products. And it's resulted in a very complicated and complex patchwork of state regulation, with the current focus, really looking at when hemp products may be intoxicating or subject to potentially unsafe manufacturing practices, where, how these terms like intoxicating should be defined, what the appropriate definitions of THC are, what appropriate levels of THC and other cannabinoids are, and how to regulate those appropriately in the hemp and cannabis channels. So we're going to go over how states are approaching the regulation of not just Delta-8, but all sorts of different minor cannabinoids, where there's some common trends and themes, and what may be upcoming. And then we'll also touch on, the federal trends in hemp. So I will kick it over to my awesome team here to get started, and we'll leave some time at the end for questions. And if you've got questions as we go along, feel free to shoot them in the chat and we'll make sure and get to them at the end.
Appreciate that, Sean. So Katie and I will just take a moment to introduce ourselves, and then we'll dive into the content. And just quick point of clarification. So in the Zoom panel, I'm sure everyone's used to it this far in the pandemic. Can't believe we're still in the pandemic, but we'll leave that for future topics. But there is a little Q&A. So if you drop your question in there, that'll kind of help us manage this rather than using the chat function. We found that gets a little unwieldy, so want to make sure all your questions are answered. As Sean said, we'll definitely leave time at the end. So with that boringness, let me introduce myself, Michelle Bodian, help Sean run the hemp and cannabinoid practice here at VS. Briefly background, with the Massachusetts Department of Ag Resources for about 5 years. Prior to that, law firm in Connecticut. So kind of bring my regulatory lens to all things hemp and cannabinoid, because this stuff, as you'll see, as I'm sure you all know, which is what brought you here today, this isn't easy. It's tricky, and working with regulators in states, have to remember they're people too, and that can sometimes lead to some of the lovely contradictions and mistakes, shall we say, that we see here today. So with that, Katie, do you mind introducing yourself? And then I'll jump into what are minor cannabinoids?
Sure. My name is Katie Whiteman, and I'm an associate attorney with Vicente Sederberg's Denver office in the Hemp and Cannabinoids practice group. I've been with VS throughout law school. So lots of experience with hemp and all those things. So if you have any questions, please let me know.
Perfect. All right. So let's dive in. What are minor cannabinoids? We are definitely going to have a lot more content on these slides than we're necessarily going to hit on today, but we wanted to make sure it's a complicated topic that you all could have a resource guide and a reference point to come back to time and time again. So as we dropped in the chat, this slide deck will be pushed out to all of you after the webinar, but I'm not going to bore you with all the details that we have on all of these slides, but essentially minor cannabinoids, we call them minor because they appear in lower concentrations than the most popular cannabinoids, THC and CBD. So just the quantity of these cannabinoids within the plant is minor as compared to major other cannabinoids like THC and CBD. And then, as everybody knows, every minor cannabinoid has its own unique characteristics and effects. It interacts with our body's endocrine system different ways, and they can be used and are being used in a wide range of products that are being added to or mixed with other major cannabinoids. We're seeing standalone CBN products, we're seeing CBN products with CBD combined. We're also seeing, 5 cannabinoids being marketed within a product. So it really does run the gamut here. Next slide. Sorry, and you're going to have to hear us say next slide just to preview that exciting topic. So, what are all these cannabinoids? We threw some together here. These are the most popular ones we've been hearing about. That said, I'm sure tomorrow there'll be 5 new, more popular ones. I think this industry has been great at, I guess good and bad at innovating. So there's constantly going to be new cannabinoids discovered, created, and that ends up being an alphabet soup. But some of the more popular ones, of the THCs, the delta 7s through 10, so 7, 8, 9, 10, obviously delta 9, intoxicating cannabinoid that we associate most often with marijuana, but then you also have CBD, CBN, CBG, CBV, HHC is having its moment in the sun these days, but you'll see the whole host of other cannabinoids that have been discovered and being researched today. Next slide. Okay, how are minor cannabinoids sourced? Every which way, I guess would be the short answer to that question. But, as we understand it today, and apologies of others in the audience, view things differently, I guess we should say that in and of itself for this PowerPoint. But, today, most minor cannabinoids are converted from major cannabinoids, meaning these cannabinoids are not occurring in large enough quantities naturally within the plant material. Therefore, there is some type of science, for lack of a better explanation, going on to create these cannabinoids, most often CBD being then converted into other cannabinoids like CBN. The conversion process varies. A lot of this is proprietary, that isn't being released by these companies who have developed and refined their extraction and conversion processes. Generally, though, it's done via isomerization techniques. And, for example, for CBN, it typically starts with raw biomass, meaning the plant material, extracting CBD from a specific flower strain. CBD is then extracted, CBD is then distilled and isolated, and then converted into the new minor cannabinoid, and using CBN as the example, which comes from CBD. All again, source material starting as hemp. Next slide. Thank you. So I think what brings you all here today, possibly to learn about minor cannabinoids, is some of the controversy going on right now. So some of these minor cannabinoids, most often the delta products, delta 7 through 10, are being marketed as intoxicating products, meaning intoxicating, like buy our product, it'll get you high. And so what the controversy and discussion is, are all cannabinoids derived from hemp lawful hemp products? Which we're hoping to answer in some details today. With, of course, the legal disclaimer that nothing we say here today is legal advice. Recommend you reach out to your attorney before taking anything we say in this PowerPoint as gospel and running with it. It is not legal advice, but want to make sure everyone has the general information, the general overview. I guess, speaking of overview, so where are we today? Just quick preview, and we'll get in a lot more detail of this. State and federal overview. So for states, some states expressly prohibit some of these minor cannabinoids products. Some allow them under certain conditions. Some states are silent, haven't really opined one way or the other. In a number of states, there's active rulemaking or legislation prohibiting these products. And these products meaning minor cannabinoids generally, but most often the legislation we're seeing today is talking about prohibiting these intoxicating cannabinoids like the delta 8, delta 7s. Lack of consistent enforcement, much like we've seen played out with CBD product. Generally, it's kind of a crapshoot about enforcement. So even if a state prohibits, not necessarily consistent on how they're enforcing. And then that's all state, and going one step up to federal. Federal law prohibits synthetic cannabinoids. Of course, why would they define that? Why would they make it clear? So synthetic is not defined, and so far it's been interpreted differently by legal authorities. We do have DEA's interim final rule that states that synthetic THCs are prohibited, but again, does not define synthetic. Next slide. So in order to figure out if all these cannabinoids are lawful, here is the alphabet soup of the federal and state laws that need to be analyzed in order to reach the end conclusion. And we will reach some conclusions today. You just got to bear with us. You know, we're lawyers, we like to show our work. So we're just going to quickly touch on the analysis that needs to be performed to get to that conclusion. So this time switching it up and starting with federal in order to make this analysis. 2018 Farm Bill, Controlled Substances Act, Federal Analog Act, Federal Food, Drug, and Cosmetic Act, plus of course the implementing regulations and FAQs and policy. Then at state level, essentially all of that mirrored at the state level. So state controlled drug laws, state analog act, state food and drug laws, and then state hemp and hemp product laws. So with that very brief overview, Sean is going to do a deep dive into all of this.
Thanks so much, Michelle. I'll dive into the federal law here. And I think it's important to remember, you know, as the previous slide showed, we're not just considering the controlled substances laws, we're also considering applicable food and drug, FDA and FTC, federal advertising and consumer protection laws in marketing and selling these products and determining whether they're legal. So the base law we're always looking at in cannabis is the Controlled Substances Act. And as you know, the Controlled Substances Act was amended in 2018 to affirmatively legalize hemp and remove it from the purview of the DEA to regulate the cultivation of the plant like an agricultural commodity. So per the plain language of the 2014 Farm Bill, hemp and its derivatives, cannabinoids, acids, salts, and isomers, with a delta-9 THC concentration of not more than 0.3% on a dry weight basis is federally legal to cultivate. And also the THCs derived from hemp are expressly removed from the CSA definition of THC, which is also separately controlled. So the Farm Bill affirmatively legalizes, the production of hemp, setting that legal standard at 0.3% for a dry weight basis, and removes it from the purview of the DEA. That being said, a substance can still remain controlled if it is a controlled substance analog. We'll get into that in more detail, but essentially if it walks like a duck and talks like a duck, it's still a duck or controlled substance. And it is a cannabis product is also a controlled substance if it's derived from marijuana, meaning derived from a plant that is above 0.3%. So delta-8 or any other cannabinoid that's derived from marijuana, Schedule 1, any derivatives of marijuana are therefore Schedule 1, and any analog we'll get into is also still a scheduled substance. Next slide. So as I said, in the Farm Bill, the definition of hemp is broad to include not just the plant, but its derivatives, extracts, cannabinoids, isomers, acids, salts. Members of Congress who participated in the drafting of the Farm Bill, have confirmed the intent of legal hemp to include the broader industry, the products that are going to be hemp derived. And, the Farm Bill also expressly preserves the authority of the FDA to regulate products within its jurisdiction, which include products for human consumption, dietary supplements, foods, cosmetics, inhalable products, medical devices. And that authority is expressly preserved within the plain language of the Farm Bill. And Congress was clear. Hemp and its derivatives are legal, and it anticipated that there would be processing involved in getting from A to B and producing legal hemp products. And it's important to note that the DEA final rule, which is also the subject of a lawsuit, which we are leading, that has oral arguments in the DC District Court in a few days here. But the DEA final, and we'll get into in more detail here in a bit, the DEA final rule was issued August of 2020, and the purpose of this final rule was for the DEA to make conforming regulatory changes because of the CSA amendment for legal hemp. So the DEA final rule did a few things, a couple of which are non-controversial and a few others that are. So the first component is that it modified the definition of THCs on Schedule 1 in the official schedule to carve out any material or compound that falls within the Farm Bill's plain definition of hemp. And then it clarifies that naturally occurring THCs in cannabis are not controlled substances, provided they are at or under that legal hemp threshold, but that synthetically derived THCs still remain controlled substances regardless of THC content. So regardless of whether it is hemp or marijuana, if it is synthetic, it is controlled per the DEA. Now, importantly, the term synthetic is not defined and is not defined specifically as applied to the cannabis plant. So there are differences of opinion as to what constitutes a synthetically derived THC, and as we will see, a different in state law interpretation as to what that term means and how it's implemented in practice. The final rule also removes Epidiolex, which is, most of you know, is the first cannabis-based, or one of the first cannabis-based drugs approved by FDA, for which the primary ingredient is CBD, derived from marijuana, and any generics of the drug Epidiolex that the FDA may subsequently approve from control. And it was in Schedule 5. And lastly, the final rule modifies the definition of marijuana extract to be limited to extracts containing greater than 0.3% THC on a dry weight basis. And the DEA final rule contains language regarding synthetics because it's undefined. That leaves it up to really broad interpretation that renders, perhaps it's intending to regulate some Delta-8 as a controlled substance because of the way it's made, as well as other cannabinoids that are made through chemical processes. It also, because it confirms that hemp over 0.3 at any point is controlled, may be interpreted to mean that hemp that is in process, where it spikes over the 0.3% limit in its processing phase before it goes back down, is also illegal, which would render most processing illegal. In that portion of the final rule is the crux of the lawsuit, HA versus DEA, that is going to be heard this week. Next slide. So what does the final rule mean? Does this mean that DEA considers Delta-8 and some of these other, processes that are made through the utilization of chemical conversion? Does it make them controlled substances? The 2018 Farm Bill does not impact the controlled status of synthetically derived THCs, because the statutory definition of hemp is limited to materials that are derived from the plant Cannabis sativa. So for synthetically derived THCs, the concentration of Delta-9 is not a determining factor in whether the material is a controlled substance. All synthetically derived THCs remain Schedule 1 controlled substances. So the DEA is saying, throw out 0.3 and drawing the line if it's a synthetic. If it's synthetic, it is controlled no matter what. So it comes down to what is synthetic. And that term, as I mentioned, is not defined, but could be interpreted based on its plain, dictionary meaning to include Delta-8, because, in many cases, Delta-8 is made with a chemical reaction that is human controlled, which would, render it synthetic under many plain language definitions. And the DEA has been, has not clarified this ambiguity in any formal writing. So there's, differences of legal opinion given DEA's ambiguous terminology here. One counter argument to the assertion that DEA controls Delta-8 is that isomerization does not convert a cannabinoid into a synthetic one, and that the definition of hemp includes all isomers. So any isomer of hemp plant would also be hemp. Another argument is that the final rule was just not the legally appropriate approach to schedule something that wasn't previously scheduled. And there's case precedent, challenging how the DEA has approached the scheduling of hemp and cannabinoids in hemp. And this would not be the first time they have attempted to regulate components of cannabis without following the proper procedure. Next slide. And then it's important to consider outside of, the controlled, or sorry, the final rule, that there's a federal analog act that applies to substances. And even if a substance is not scheduled, if it is an analog of a scheduled substance, then it will be considered a scheduled substance. And a substance is considered an analog. I mentioned the walk like a duck, talk like a duck. If it has the same chemical structure and effect as a scheduled substance. There's a two-pronged test, and if it's controlled substances analog, it's subject to the same controls. Next test, or slide. So the two-pronged test starts with chemical structure. If the substance, at its chemical level is substantially similar to a controlled substance, it will meet the first prong. And this was originally designed to capture sort of, designer drugs and K2 and spice when manufacturers would, try and make the same substance by manipulating a single molecule when it was otherwise substantially similar. Next slide. So when the court looks at chemical structure, it's quite a sophisticated analysis. They're looking at whether they have substantial similarity, and often they'll get, the testimony of chemical expert or of, chemists and other experts. With Delta 8 and Delta 9, they differ with the location of one single double bond, so they're not identical, but they do have actual and perceived chemical and pharmacological similarities. And the DEA actually lists Delta 8 as other names for THC. Next slide. The second part of the test is effect. So if a substance has the same actual or intended effect as a controlled substance, then it is also controlled. And they'll look at the effect, whether it's substantially similar to or greater than the stimulant, depressant, or hallucinogenic effect of the central nervous system of the Schedule 1 or 2 substance. Next slide. So with respect to Delta 8, it's been generally concluded that Delta 8 does not have a pharmacological effect that's greater than Delta 9. It's understood to be less potent, but still psychoactive. There was a 2018 GRAS notice for hemp protein powder approved by FDA that referenced a study assuming that Delta 8 THC is about 75% as psychotropic. So it's less than, not greater than. But is 75% substantially similar? That would be a question for a court to consider, and they would look at the pharmacological effects as determined by chemists and pharmacological experts. So with the Analog Act, each any cannabinoid that's new, call it THCX or CBX, the next one that comes, even if it's determined it's derived from legal hemp, one does need to look at, could it be a controlled substance analog, and determining whether it's legal under the Controlled Substances Act. And even when it's legal under the Controlled Substances Act, to be legally sold, one has to look at the federal food and drug law. So I'll turn it over to Katie here to hit on the FDA.
And by Katie, she does mean me. So, and to answer, I just saw a question pop in the chat. We'll be hearing about CBN or HHC. For the purposes of discussing minor cannabinoids at the federal level and discussing the two-pronged test and analog, we're using Delta 8 just as a cannabinoid example, essentially. But the two-pronged test that's highlighted in the Analog Act, the Controlled Substances Act information, as well as now FDA, all of this analysis is applicable to all cannabinoids. So even if we're not touching on the exact specific cannabinoid you're interested in, most of this information is still applicable. And as Katie will touch on the state law information, states sometimes have specifically named cannabinoids in greater detail than we have for the federal government. So speaking of the federal government, as Sean said, there's controlled substance, DEA, the big bad's scary, but I will say FDA can make your life equally as miserable if they wanted to. So we're just going to briefly touch on the Federal Food, Drug, and Cosmetic Act. So as many of you are aware, a new dietary ingredient would be subject to an NDI notification, essentially saying the ingredient is safe for its intended use. You're prohibited from introducing or delivering in interstate commerce, meaning sales between two states, any food for which it's been added either an approved drug product or a drug for which there's been substantial clinical investigation that's been made public. So essentially this prohibition would not apply if a subject ingredient was marketed in the food before there was a clinical investigation. So all of that saying, some ingredients are prohibited, some are permitted, but only in certain circumstances if you're able to document those circumstances. Next slide. So in order to figure out whether or not a new cannabinoid was lawful under the Federal Food, Drug, Cosmetic Act, again, two-step analysis. We like our multi-pronged analyses here. So it is required to do these two steps to determine whether a novel substance such as delta-8 THC or CBN or HHC is suitable for use in food, and if it is suitable, under what conditions. So first, whether the delta-8 THC, again, using that as the placeholder example, whether it's precluded from use in a food or dietary supplement due to its prior use in approved or studied drug products. So FDA does publish a list of approved drugs and does publish a list of whether there are clinical trials undertaken. So we need to do your research, your homework to figure out if this cannabinoid has been subject to any approved drug or whether there's drug trials going on currently using this as an active ingredient. Then the second prong, whether this cannabinoid, delta-8, complies with FFDCA requirements to demonstrate the safety of the ingredient under its tested use. So again, that NDI notification. Next slide. Okay, so a food containing a delta-8 ingredient is lawful if it was sanctioned or approved by FDA or USDA between 1938 or 1958 for its intended use. So here we know that this is not applicable for delta-8. This was not a cannabinoid that was sanctioned or approved during these years. So then dropping down, if it is generally recognized as safe for its intended use, again, generally recognized by experts as safe under the intended condition based on extensive use of the product in food or published scientific data. So wanted to be able to gather that documentation to submit a GRAS notification or pursuant to a food additive regulation promulgated by FDA. Next slide. So that was food, and then talking about dietary supplements is depending on how you're marketing your product with your cannabinoids. That'll depend on whether FDA is classifying your product as a food or a dietary supplement. So a dietary supplement containing delta-8 or any other minor cannabinoid may be lawful if it has done a new dietary ingredient, again, the NDI, that was subject to pre-market notice requirements. And this pre-market notification must present enough data to establish that the THC delta-8 ingredient does not present a significant or unreasonable risk of illness or injury. Essentially, if used as directed, whether or not that there's potential harm to the consumer. And then lastly, the delta-8 THC ingredient would not, again, present a significant unreasonable risk of illness or injury when used as directed on the label. So just to wrap up, there's the federal law consideration, Controlled Substance Analog Act, federal law consideration, food, drug, and cosmetic, and then we would drop down to state-specific analysis. So obviously we didn't reach any conclusion under FFDCA regarding the lawfulness of these cannabinoids because it really depends on the product, how it's being marketed, and whether or not you've done a GRAS notification, an NDI notification, whether these clinical trials have been conducted, your exact processes of how you're creating your cannabinoids. So we're not able to, on the FDA side of things, reach a bright line conclusion. It'll come down to your product, how it's manufactured and how it's marketed. But we've got a little bit more bright line clarity at the state level. So I'm going to turn it over to Katie to be giving her overview.
Sure. So states obviously take varying approaches to the regulation of certain cannabinoids, and this is in absence of clear federal law and guidance on the topic. So that's why states are stepping in to regulate some of these products. Some states prohibit Delta-8 or other cannabinoids through food and drug laws, the same way the FDA would prohibit their inclusion in foods, dietary supplements, things like that. Some states actually prohibit cannabinoids through hemp or criminal laws. So actually criminalizing or adding the substance to the controlled substances list. Other states have just released policy statements interpreting current laws as prohibiting cannabinoids such as Delta-8. For example, the Colorado Department of Health and Environment released a policy statement prohibiting the use of chemically modified or converted cannabinoids in hemp products, but this is just based on existing law. There has been no actual change to Colorado law. It's just their interpretation of law as it currently stands. Next slide, please. So several states expressly prohibit Delta-8 or other intoxicating cannabinoids. The issue here is intoxicating is not always defined, so it would be up to the regulatory body to determine whether that cannabinoid is intoxicating. Some of these states include California, Colorado, Massachusetts, and New York. There are a few states that expressly permit Delta-8 with certain restrictions. Florida allows Delta-8 products, but all products have to comply with the labeling and testing requirements for hemp products, and they must have a Delta-9 THC concentration of no more than 0.3%. And this information, again, for Florida comes from a policy statement by the Florida Department of Agriculture and Consumer Services, and it's not necessarily binding on other agencies. So there is the potential that other agencies could interpret Florida law differently and conclude that Delta-8 is prohibited. And one new state, South Dakota, just passed a law recently within like the last week or so that allows the sale of Delta-8, THCO, and HHC to those 21 and over. Next slide. So Louisiana, they actually allow Delta-8 in hemp products, but hemp products cannot have more than 1% total combined THC concentration. And in addition to that, hemp products must have no more than 0.3% Delta-9 THC. And the total THC concentration includes Delta-8 and other THC isomers. Next slide. So Oregon has taken a different approach, and they have established THC limits per container and per serving. They've actually established two different sets of limits, one for products that are sold to those under 21 and one for products sold to those over 21. And hemp products can be sold to minors, but they must contain less than 0.5 milligrams of total combined THC per product, and no other adult use cannabinoids. And then so for consumers over 21, they have limits for actual different product types. The state also defines artificially derived cannabinoids to include Delta-8. Delta-8 products are permitted until July 2022, at which point they will not be permitted. And products containing CBN created through isomerization may be sold until July 2023. Next slide. So here's a rundown, and I have a few slides on this, of pending bills that would regulate Delta-8 or other cannabinoids through state law. State legislative sessions vary. So these bills have currently been filed, but because legislative sessions are not the same for each state, there could be other bills introduced in the future. So it's really important to stay on top of all these changes. Bills can also be amended in the future to include language affecting the legality of certain cannabinoids. So it's really important to watch all of these. There are certain tools you can use to keep track of these bills. Legiscan is a good one, but that you kind of have to do a manual search there. There are paid tools that you can use that will track these for you and send you updates. And then, of course, we here at Vicente Sederberg also track these bills and can provide monthly updates on everything going on in state legislatures. Every state has a different process, but generally the bills must pass both legislative houses and then be signed signed by the governor. Some are effective immediately and some provide for a later effective date. So it just depends on the state. Some bills directly address Delta 8, while others prohibit intoxicating cannabinoids or cannabinoids created through isomerization, which could include Delta 8 and others. And there's not always a clear definition of intoxicating, and often the interpretation is left up to regulators. So I'm not going to read through all of these bills, but we will provide you the slides later. But I'm just going to touch on a few that are kind of important and a little bit different than the rest. So in Arizona, SB 1715 defines hemp-derived manufactured impairing cannabinoids. And this definition includes any cannabinoid derived from hemp and altered by chemical reaction. But it specifically calls out Delta 8, Delta 10, HHC, THCP, THCO. And it does exclude CBD, CBG, and CBN from that definition. Next slide, please. In Kentucky, SB 170 prohibits the sale of intoxicating cannabinoids, but intoxicating is not defined. So this leaves the interpretation of intoxicating up to regulatory authorities or law enforcement. The bill does, however, explicitly prohibit Delta 8, Delta 10, THCO, THCP, and HHC. And then in Louisiana, despite the policy statement that Delta 8 is allowed under 1% total THC, HB 758 has been introduced, and this bill would prohibit hemp products from containing any cannabinoid created by chemical reaction. And it doesn't call out specific cannabinoids, but again, likely would include Delta 8 and other cannabinoids created as such. Next slide, please. And then in South Dakota, who recently enacted a law allowing the sale of Delta 8, THCO, and HHC to those 21 and over, there's also another bill that has been introduced that would prohibit products containing cannabinoids created through isomerization. Next slide. And then finally in Virginia, SB 591 was passed by the legislature, and it's been on the governor's desk for a while, but the governor actually rejected the bill and returned an amended version of the bill to the legislature. And the amended bill will have to pass the Virginia House and Senate. The governor's version of the bill removes a per package and per serving THC limit. So that was included in the original version. It's no longer in the governor's version, but the bill, the governor's version does permit the Board of Agriculture and Consumer Services to adopt regulations that include a per package and per serving THC limit. This will again go through the normal regulatory process, which would include holding public hearings and public comment. So there would at least be some opportunity for input on those limits should they be established. The governor's version also adds THCP and THCO to the state's list of controlled substances, and it prohibits the sale of hemp products for human consumption that contain synthetic Delta 8. But again, synthetic is not defined. And I think that is it for pending bills. I think Sean is going to take over and talk about some of the pending federal legislation.
Thanks, Katie. Yeah, so I think folks are aware of most of the pending federal legislation related to hemp, and that there is an upcoming 2023 Farm Bill, which will, hopefully address some important issues like whether the appropriate THC limit for hemp may be 1%, perhaps, more protections for work in progress hemp. There's efforts for, distinguishing between, fiber and grain hemp and cannabinoid or floral hemp, and reducing, testing and sampling standards for hemp that's not intended for consumable use. So I think those will be sort of the core focuses of the industry in the 2023 Farm Bill. There is potential that in that Farm Bill, there is an opportunity to address regulation of intoxicating cannabinoids or agency authority of such. And it's to be determined whether that will be the vehicle or whether there will be agency guidance or other bills that are successful that address these in the interim. The core pieces of federal registration for hemp include efforts for FDA regulation of hemp. There's Senate Bill 1698, which would regulate CBD as a dietary supplement and food or beverage additive. There's continued efforts to get support for that bill it's really been a bipartisan support here. There's also still HR 841 in the House, which is Representative Schrader out of Oregon's bill and Representative Griffith. This, unlike the Senate bill, would regulate CBD only as a dietary supplement. There's efforts to get this bill heard in the Energy and Commerce Committee. It has been out there for quite a bit without getting a hearing. And there's continued support for that bill, but I would say perhaps more focused on the Senate bill, which would regulate both CBD in both dietary supplements and food. Another core bill that many folks are probably aware of this year is Representative Pengray's bill, HR 6645, otherwise known as the Hemp Advancement Act of 2022, which would do a number of core things to improve the 2018 Farm Bill's hemp provisions, provide more protections for activity, and provide greater flexibility to growers and processors. This bill does attempt to address the synthetic issue, and there's efforts to continue and to improve that language to have a consumer protection focus, while still sustaining legitimate hemp market and removing some existing provisions in the Farm Bill to give greater flexibility to growers. There's also on the FDA front, HR 6134, which would also ensure FDA regulation of CBD products. I would note that in the years past, it's been difficult to get progress on these FDA regulatory bills despite bipartisan support. There continues to be turnover and delays in the FDA advisory committee, and the FDA is still gathering the safety data it needs. And what these bills would do would remove generally the drug preclusion provision that prevents FDA from regulating CBD because it was studied as a drug, and allows it to be regulated as a food or dietary supplement, while the FDA further assesses regulations. But it's been difficult to get movement on these bills historically. And otherwise, there's still a lot of support and attention on banking reform for both cannabis and hemp through safe banking or competes, and hopefully progress on that. I would say that's the most likely effort to succeed this year. But yeah, I think there is going to be a lot of focus and a lot of important items in the 2023 Farm Bill could address, including regulation of animal products, protections for work in progress hemp, protections for transportation, and I believe the increasing the legal THC standard to 1% still remains a priority of most industry stakeholders.
Awesome. Thanks, Sean. And, I know that with all these moving pieces and everyone trying to figure out what's lawful and what's not, as I mentioned, states don't necessarily always get it right. And we did just want to touch on a number of lawsuits related to this. And if you notice, we marked Texas down as prohibited state. Looks like someone caught that and commented in the chat. So in Texas, there is some ongoing litigation around how Texas implemented their ban on Delta-8 products. We're taking the conservative approach of possibly the non-optimistic view of the success of this lawsuit. And again, nothing related to the merits of the lawsuit, but potentiality for the state agency to revise its rulemaking through proper channels, ultimately resulting in the same end result of classifying Delta-8 in Texas as a cannabinoid, but that is subject to ongoing litigation, as well as in Georgia. There's litigation related to a local district attorney seized Delta-8 products. He was prosecuting retailers. The retailer selling those products was successful in obtaining an injunction, preventing, at least in that district attorney from enforcing against retailers. So restraining orders in effect for 30 days, a lawsuit going on in Kentucky. So, people are not taking some of this ambiguity lying down. They are looking for that regulatory certainty and moving ahead with lawsuits against, right now, state agencies. Obviously, Sean mentioned some federal lawsuits, which good transition into the questions, because I think some of them are directed at the ongoing litigation. So one, I'll apologize, Katie's camera broke. So be wary of products purchased on Amazon. And second, we'll dive into the questions for now, but feel free to keep populating. First one, Sean, I'm actually going to kick this one to you. I don't know the answer, and I'm going to moderate so I can cherry pick the questions. So someone is asking, will there be a live stream of the oral arguments in that lawsuit against DEA that you mentioned?
I believe there will be a live stream. We're still waiting to get the information, but we'll share it with our email list if we do get it.
Perfect. And I'll stick with you because it's similar topic. So in the lawsuit challenging the DEA rule, is it challenging the definition of synthetically derived, or is it related to other aspects of the DEA final rule?
The lawsuit's focus is the portion of the DEA final rule that indicates that work in progress hemp exceeding the 0.3 limit would be a controlled substance. So it's narrowly focused on that component.
Okay, perfect. Guess I'll awkwardly ask myself this question. What is the impact of the DEA letter to the Alabama Board of Pharmacy? And for those of you who's not super entrenched in this area, so the Alabama Board of Pharmacy, or BOP, had issued a question to DEA asking for the controlled status of Delta-8, and DEA did reply, and that letter was publicized, several months ago at this point. I will say some have interpreted that letter to be DEA conceding that Delta-8 and other intoxicating cannabinoids are permitted. Others have interpreted that letter to say, DEA has not said anything new or different from what it said in the interim final rule that they previously issued. So all of that, I guess, ambiguity to say there's conflicting views as to the impact of this letter and therefore the implications of selling these products. And I'd say right now, given everything we just went through on the federal legality and the ambiguity, take caution when selling these products, because we don't have a definitive yes, no statement. There's a lot of ambiguity and subject to interpretation, and us as lawyers are happy to provide our suggested interpretation, but ultimately it comes down to federal and state regulatory agencies' interpretation, and we don't yet have 100% clarity on that topic. I'm gonna, Katie, ask you, even shadow self who's not on camera, to answer this one. You said Texas prohibited Delta-8, but Delta-8's being sold everywhere in Texas. I guess, do you know who prohibited Delta-8? Can you talk a little bit about that agency who issued guidance and where the lawsuit stands, if there's any more details beyond what I had already said?
Sure. So the Texas Department of State Health Services actually changed the definition of THC a while back to include Delta-8 THC, which would prohibit any product over 0.3% combined THC. And the lawsuit right now is company that is making these products is suing the Texas Department of State Health Services because they are saying that the department did not use the correct procedures when making that definition change. So before the lawsuit and the temporary injunction was issued, the Department of State Health Services also put out a policy statement on their website saying that Delta 8 was prohibited. Once the temporary injunction was in place, they have since removed that. Even if the lawsuit, though, is successful from the plaintiff's side and this, the Department of State Health Services is not allowed to keep their new definition of THC, there is nothing stopping them from going back and redoing the regulatory process to once again prohibit Delta 8. So that is definitely something to look out for, despite the outcome of the lawsuit. Currently, the lawsuit is in brief writing stage. So it's at the Supreme Court. They're writing briefs. Oral arguments were postponed, but they should be coming up fairly soon. Some of the briefs are in and a few are still being written.
And I would say that the Texas legislature, I know, is already looking at legislative approaches to Delta 8, regardless of the lawsuit, prohibitive manner. So I think that'll be a key state to watch.
Perfect, thank you. Then let me flip back to questions. Maybe, Sean, if I can ask you about California. Hemp-derived Delta 8 is prohibited in California. Do you foresee marijuana, cannabis-derived Delta 8 facing challenges in California? And maybe even if not California specifically, but do we know how the cannabis industry is viewing these cannabinoids, cannabis-derived Delta 8 products and others coming through the licensed regulated cannabis scheme?
Sure. I would say California, in addition to other states, is going to look at it on the cannabis side, from the consumer safety perspective, and like many states have done, regulate around potentially unsafe processes, and we've seen in many states agency guidance as to what an unlawful synthetic process entails. So I could see, California focusing on what is a safe process, as opposed to, in other states, as opposed to a de facto ban on the cannabis side, rather than the approach that's being taken on the hemp side, which is looking at not just the safe process, but the intoxicating effect. I think some of these intoxicating cannabinoids will be limited to the cannabis channels. But the types of products that can be made will depend on whether a process is determined to be compliant with safety standards that are applied to other cannabis products.
Perfect, thank you. And Katie, since you just talked so eloquently on Texas, can I ask you to speak a little bit about Florida? We've got a question saying, FDAX has embraced the 0.3% max THC for all cannabinoids. Could you just talk a little bit about the guidance that has come out of Florida? We had listed them as a permitted state.
Sure. So Florida does permit Delta 8 that's one of the only cannabinoids that they actually called out, but they do permit that in products in Florida that have a Delta 9 THC concentration of less than 0.3% or no more than 0.3%. So under the Florida Department of Agriculture and Consumer Services guidance, technically Delta 8 products can contain more than 0.3% Delta 8 THC, but cannot contain more than 0.3% Delta 9 THC. And I know they've come out and said that they've been going into stores and testing products, and that they've been finding that a lot of these Delta 8 products do test over the Delta 9 THC limits, and they're pulling those products from shelves. But as of right now, I haven't heard of any enforcement against Delta 8 products that have a less than 0.3% Delta 9 THC concentration.
Perfect, thank you. I'll take this one. Are states trending towards interpreting synthetic as using a chemical reaction, and how would cannabinoids that I'm going to say undergo a chemical reaction change due to heat treatment be interpreted? I mean, short answer, as you saw, and you'll see in the slide with more detail, states are all over the place as to how they're interpreting information. I haven't seen a definition of synthetic that gets into chemical reaction to the point of defining it, talking about heat as the catalyst to make that conversion. A lot of states are casting a broad net in statute and kicking it down to future regulation. Have to remember, these are not typically scientists drafting this language, and trying to get bipartisan support to get these bills passed takes some doing. So most often these bills generally talk about a class of products they're trying to prohibit without necessarily even naming cannabinoids, not necessarily talking about science, since that generally scares a lot of people and will slow down the process. So most of them are pretty broad, but we can see future rulemaking getting into the technical information and maybe states trending in the direction of talking about chemical reactions for their definition of synthetic. And Sean, I'm going to ask you, we've got a question about whether there's going to be any discussion of what's going on in Colorado regulatory matters dealing with intoxicating cannabinoids. So is Colorado a state where there's something happening, which we might want to notify the public to keep an eye on bills being filed?
Yeah, absolutely. In Colorado, there's a bill seeking to, regulate intoxicating cannabinoids in the marijuana regulatory regime and draw the line between intoxicating and non-intoxicating cannabinoids. Right now there's kind of a stakeholder process between the various agencies and cannabis and hemp stakeholders to refine these complicated definitions and set up a rulemaking process to further define things like intoxicating. I think Colorado, like many other states, is looking at the science and the data and other state precedent to support what appropriate THC limits and serving size and package size limits may be for certain products, and really where to draw the line between intoxicating cannabis products that may be more appropriately sold in the marijuana industry. So I would say Colorado is definitely a key state to watch. I think Virginia was also, is it Virginia or Vermont today, Michelle, that the governor signed the bill?
It was Virginia that he sent back the amended legislation and that removed the milligram limits, but's kicking the can down the road. So not completely shutting the door, but at least pulled that language out of the bill for now in Virginia.
Yeah. So I think Virginia is another one to watch as it gets to rule, to look at where they draw that line, and as far as milligram limits and serving sizes. And I think, like we talked about, Texas, California, there's a lot of action here. And I think states, it's a real challenge to adopt regulations that are really more appropriate for FDA, and where we're accustomed to having a product safety process at the federal level to overlay state regulation. So I definitely encourage everyone to engage with regulators and industry groups here, because it's complicated, and the feedback from the industry is really critical to making good policy, including here in Colorado.
Great, thank you. I'm gonna put a pin in it because we're at time. If we could just advance to the last slide, which shares our contact information. Obviously complicated topic. We've got a whole host of resources besides our PowerPoint that you'll get a copy of to help you navigate this. We really just scratched the surface here today, really emphasize doing your due diligence and homework on federal law, state law before selling or introducing any of these products. As you saw by all the pending bills, what we said today is going to be stale in 2 hours. So make sure at the time you're ready to sell, you have the latest and greatest information. So feel free to reach out to us with any questions that you have, but really appreciate everyone taking the time to join us and dive into this topic. And then as what's been going on in the chat, the copy of this PowerPoint as well as this put up on our YouTube channel. So you can watch this over and over and over again at your leisure. It's where it gets more fun the more times you watch it. So really appreciate everyone joining us today.
Thank you so much, everyone. And you can feel free to contact anyone here from the Hemp team if you're interested in our compliance guides or in getting involved in some of these legislative efforts or diving in deeper to any of these issues. And we really appreciate everyone's time. And thanks to the awesome Hemp team here, Katie and Michelle and Andrea in California, who's supposed to be here but was sick today. So we've got a great team here at your service.
All right, bye everyone.
Yeah.